Hello, I am Giuseppe Rocchè, postdoc researcher belonging to the University of Palermo. I am here to deliver a lesson. The title of the lesson is Mental Contamination and Inadmissible Evidences. This lesson is part of the Recognize project, a project on law and cognitive science, which is funded by the Erasmus Plus project of the European Union. The lesson is articulated in two parts, which are recorded separately. We will start then from section 1. According to the ideal of rule of law, judges and other public officials ought to follow the law. This means that they ought to ground their decisions only on reasons which are legitimate, good reasons, according to the legal system in which they operate. Still, judges may depart from the application of the rule. The departures may be occasional or systematic. Systematic departures may be divided further in conscious departure and unconscious departure. Conscious departures, let's think to a judge who is heavily oriented by her political preferences, may be the object of study of disciplines like history, sociology, or law and economics. Next to conscious departures, there are unconscious departures. There are factors which lead judges towards a wrong decision, towards the disapplication of the law, even unbeknownst to them, that is, against their will. This second phenomenon, systematic errors committed by judges caused by factors which act unconsciously, is the object of interest of the psychological inquiry about law. For the purpose of this lesson, we may group these factors in three sets: irrelevant information, relevant but inadmissible information, and disturbing factors which are not information at all. We will start from this last one. So, irrelevant factors which are not information. An example of the first type, is represented by the impact of meal breaks on parole decisions. In a very famous experiment, it has been shown that hunger and fatigue make judges more prone to deny parole, provided that parole denial is the default option of their judgment. I don't dwell a lot on this phenomenon since you have a lesson which is dedicated to it in part. The second type of factors is that of irrelevant information, or perhaps it's better if we say radically irrelevant information. We will see why. A source of good examples is provided here by the phenomenon of anchoring. Anchoring describes a phenomenon according to which numbers inserted in a scenario are often taken as relevant for the solution of a problem related to the scenario, even though they are totally irrelevant. In a study, for example, judges have been asked to quantify a fine for the violation of a noise ordinance. The author of the violation is a nightclub. Some of the judges knew a version of the case in which the nightclub was identified as Club 11, 866 on the basis of the street address. Other judges read a version of the story in which the club was identified as Club 58. The number of the identification anchored the judge's response, and those who identified the club with a higher number were more prone to impose a higher fine. We must note, in this case, that nobody in an experiment like this would think that the number used for the identification of the nightclub has any relevance. We may also quote another experiment that is similar to this. In another experiment, legal practitioners have been instructed to take the point of view of judges. But before judging the case at hand, they have been instructed to throw a pair of dice to determine randomly the prosecutor's sentencing demand. The prosecutor's demand was clearly relevant for the decision, especially because it was established by throwing a dice. Still, the sentencing decisions issued by the participants were affected by the number they got by throwing the pair of dice. So even a roll of the dice affected judges' sentencing decision in a hypothetical case like this. Again, we must pay attention on this. In this experiment, the legal experts know from the very beginning that the number in the dice is irrelevant for the decision, but nonetheless, they are affected by it. So the information in these two experiments is clearly irrelevant, radically irrelevant. We can move to the third type of disturbing factors, which is the core of this lesson. Relevant but inadmissible information. At times, the law dictates that certain information cannot be used to ground a decision on a concrete case. The law excludes certain considerations. We have what we will call exclusionary rules. In many cases, the law doesn't bother to exclude certain information. If the information is blatantly irrelevant, the law doesn't bother to exclude it. This is the case we have seen before when we have considered the experiments about anchoring, with the one with the nightclub or the night with the dice. The law doesn't bother to exclude explicitly that random numbers would be used to adopt the decision. The law uses exclusionary rules when the information is either clearly relevant or relevant, though unclearly. When an information is clearly relevant, we mean that the information reflects certain facts which are reasons to adopt a certain decision. When the information is unclearly relevant, we mean that the information may reflect facts which are reasons. So, some information clearly reflects facts that are reasons. Other information may reflect facts that are reasons. But according to exclusionary rules, we must discard all this information. This may sound like a paradox. Why should we exclude reasons or possible reasons in adopting a certain decision? What reasons could there possibly be for excluding other reasons? The law may be interested in excluding relevant information for two main sets of reasons. The first set of reasons is that of epistemic reasons. For epistemic reasons, we mean reasons which have something to do with fact-finding, reasons which have something to do with the reconstruction of the facts. We have then intrinsic or epistemic exclusionary rules. The existence of these rules is justified by the fact that sometimes the exclusion of irrelevant information is useful for the reconstruction of the truth. They are then truth-enhancing rules, rules which are useful for the pursuit of truth. Next to these rules, we have extrinsic, extra-epistemic exclusionary rules. Extrinsic or extra-epistemic exclusionary rules are aimed at advancing certain policies unrelated to fact-finding, rules which are aimed at fostering important values, regardless of their impact on the pursuit of truth. The distinction is not as clear as it may seem at first glance. The two functions of exclusionary rules are often conflated. Imagine an interrogation in which torture or other coercive means are used to obtain information. The inadmissibility of information obtained by these means may be based on humanitarian concerns, but also on the fact that it is unclear how valuable this information may be, provided that it has been extorted through controversial methods, even in terms of the pursuit of truth. Another clarification is in order. Some epistemic exclusionary rules are justified because they target information which is dubiously relevant. Think again about a confession acquired through very controversial measures. It may be claimed that a confession obtained through very controversial measures may be devoid of any epistemic value. In these cases, it is not perfectly clear whether the information is better conceptualized as relevant or irrelevant. Anyway, even if we think that it is better to call information like this irrelevant, the information is not irrelevant in the same sense in which random numbers, remember the experiment with anchoring, are irrelevant for the decision. In the case of the confession extorted through torture, we are dealing with discredited, dangerous information that anyway retains a certain strength, a certain relevance for practical purpose, an information which is somehow tempting for practical purposes. Let's now give a look to an experiment regarding relevant but inadmissible information. We will look at an experiment involving 256 judges of the United States. The methodology was very simple. The experimenters administered the questionnaire with some cases and then collected judges' responses about these cases. Judges were divided in different groups. There was a control group in which a certain information is not provided at all, and one or more suppression groups. That is, groups in which the information is provided, but judges are asked to ignore it. We will consider only one of the 7 cases submitted to the judges by the experimenters. The experimenters wanted to test the efficacy of a rape shield statute. The rape shield statute, which has been considered, limits the admissibility of information about chastity and the sexual history of the people involved in the case. The purpose of this provision conflates both extra-epistemic concerns and epistemic concerns. On one hand, the law wanted to avoid hostile examinations of the alleged victim by the defendant's attorney. Hostile examinations in very intimate aspects of the life may deter the victim from pursuing the case against the author of the crime, in fact. On the other hand, there are epistemic concerns about the admissibility of evidences regarding the sexual history. The details about the sexual history may be devoid of any relevance for the case at hand. They may be irrelevant and create a prejudice about some of the parties. Or perhaps they may be relevant, but in a very uncertain sense. According to some, for example, a promiscuous sexual conduct may suggest that the sexual intercourse has been consensual. According to others, a promiscuous sexual conduct is a favorable condition for the credibility of a complaint regarding a rape. Sexual experienced people may be more credible since in their long story of sexual intercourses, they have not falsely accused their partners of rape. So the information may be relevant, but it is disputable in which sense it is relevant. Its use may generate confusion or trigger prejudices. This is an epistemic reason to exclude the information. The plot in the experiment is the following. A college student is accused of having sexually assaulted a fellow student during a fraternity party. The complainant had been seen speaking with the accused guy at the party, and then they have been seen moving in a room together. Apparently, the girl was drunk and the boy was helping her to walk. The complainant admitted to having intercourse with the defendant, but denied that she had given consent. The facts indicated that the complainant immediately contacted police after the incident and had bruising consistent with a sexual assault. Judges are then asked whether they would convict the guy for sexual assault, this both in the control condition and in the suppression group. But there is a crucial additional detail to take into consideration. In the suppression group, the experimenters added another information. It was stated that the defendant's attorney tried to introduce the following evidence. In his defense, Mr. Geiger is trying to introduce testimony from 5 other students, 3 male and 2 female, that Mrs. Smith had a well-deserved reputation for being sexually promiscuous. This includes one of Mrs. Smith's best friends who will testify that before Mrs. Smith met her fiancé, she had trouble remembering what fraternity house she woke up in each Sunday morning. Another witness, former roommate of Miss Smith, will assert that Miss Smith liked to loosen her inhibitions with a few beers too many and then have rough sex with the first guy she saw. It was also added that the prosecution has moved to exclude such evidence on the ground that it violates Arizona's rape shield statute, which forbids the introduction of evidence concerning a victim's chastity or reputation for chastity in cases involving sexual assault. Judges were then asked whether the information should have been excluded, as requested by the prosecutor, or admitted. In the control condition, instead, we must remember the judges didn't know anything about the sexual history of the alleged victim. So there was no problem with suppression because there was not any information to suppress. Now, we have 3 groups of judges. Those in the control condition who never heard of the testimony, those who heard and judged that it was inadmissible, and finally those who heard the testimony and admitted it. The interesting result is that while the conviction rate was of almost the 15% among judges who have not been exposed to the testimony, this rate was only the 20% among those who heard the testimony but suppressed it. Statistically speaking, there wasn't a difference between the judges who read the evidence and suppressed it and the judges who read the evidence and admitted it. In effect, it made no difference whether the judges who read the inadmissible evidence excluded or admitted it. Regardless of their rulings, they relied on it. The behavior of the judges who admitted the evidence may be interesting from the point of view of criminal law or sociology of law. But what is interesting from a psychological perspective is the behavior of those judges who excluded the evidence, believing that the information was inadmissible, and nonetheless behaved like those who admitted and relied on the evidence. For these judges, the evidence unconsciously affected their judgment. So the first section of the lesson is ended. We will continue the lesson in another recording.